Hi viewers, once again my name is Tabitha Chikeya and I'm your host on our channel Understanding the Law with Tabi. Last week we had an interesting discussion on inheritance with a will. We talked about the pros and the cons. And if you still remember, we said that a will is not the safest way in which you can protect your investments for generations and generations to come. And I left you with a question. The question was, then what is the most secure way to protect your investment for this generation and generations to come? Before we delve into that, let me give you an interesting scenario. I've had many people asking me, well, you're saying wills are not very secure. Why are you saying that? Is there any legal justification for you to say that? Let me give you one case law in which a person was disinherited from a will until the courts had to intervene. In this case, the scenario goes as this. Mr. X was married to Mrs. X and they were married for the past 42 years. They had their children and eventually they had grandchildren. And upon his death, Mr. X had left a will. And in that will, they only had one property. And this property, mind you, is the property in which Mr. and Mrs. X were staying for their lifetime. During the 42 years of their marriage, they stayed in that household. But do you know what? Mr. X bequeathed that very house to his granddaughter. And by saying that, he said, I do not want my property to go to my wife. Once my wife dies, her household will take that house. And you know, the different things that we as cultural people, the conceptions and the misconceptions that we have. So due to these misconceptions, Mr. X left the house to the grandchild. And the grandchild now wanted to evict the grandmother from the house until the courts had to intervene. The case is Chiminya versus Estate Late Chiminya. It's a High Court case, 272 of 2015. You can check it out. So the solutions which I'm proffering are coming from real life examples. So the question is, what is the most secure way to protect our investments? And the answer is a trust deed. Many of you might be asking, what is a trust deed? How does a trust function? How is it registered? How secure is it? So let me try to define a trust to you. A trust is a legal vehicle in which it embodies a relationship between three parties. The first party being the founder of the trust. The founder of the trust is the person who says, well, I've got A, B, C, and D properties. I want these properties to be invested or maybe to be protected for the benefit of B. And then C is the person who's then coming in to manage these investments. So A is the founder. He or she is the owner of the properties. B is the beneficiary to these properties. And C is whom we call the trustee, the person who is managing the properties. And the trust document or the trust deed is the vehicle in which these investments or these properties are meant to benefit the beneficiaries. So let me try and simplify this. For example, I've got my house in Emerald Hill. I've got my house in Zimbabwe. I've got another house in South Africa, in the UK. And I've got maybe 5 children. And I'm saying, when I die, I want my properties to benefit my children. And even so, before I die, I want my properties to benefit me and my children as well. I go to a lawyer who's called a notary public. And I say, Mrs. Lawyer, Mrs. Chikeya, I want you to draft a document in which my properties will be secured. And I say, what you need is a trust deed. Mrs. B will now say, your house number A must benefit the children in that it must pay their school fees. House number B must benefit the children in that maybe if their marriages do not work wherever they are, they can come back and stay in that house. House number C maybe will cater for their clothing and their welfare. Maybe house number D will be used as a backup plan in case anything happens. So the trust deed will stipulate the way in which you want the properties to be dealt with. And the trustees now come in as managers of the property. So the duty of the trustees now is to say, okay, Mrs. B has got 5 children and there is one child who wants to go to school. This house, let's put tenants in this house. And from the process of the rentals, let's take child number 3 to school. So you see, through a trust deed, it means that your properties are protected for generations and generations to come. And you can even take care of your children even long after you're gone. Have you heard of stories whereby maybe someone was wealthy when he was still alive and he left multiple properties, but those properties vanish in the instant that the person dies? Either the relatives take the properties, or either the children who would have been given the properties misuse these properties, or maybe the wife is remarried and after being remarried she disposes of the properties in a dubious manner. Or maybe it's the wife who dies first and the husband remains and he gets married, and after getting married the new wife maybe might use the properties to the detriment of the surviving children. So when you have a trust deed, it means that your wishes are respected even long after you're gone. So which is why I recommend people to have their lawyers draft what are called trust deeds, in which the properties will be secured for future generations. And another thing about trust is that this legal document, it is a legal person in terms of the law. It has got separate legal personality, which means that once I put my property in a trust deed, when I die, it means that the property is not subject to estate duty, it's not subject to the master's fee, and it's not subject to what is called the executor's fee, because it is not part and parcel of the deceased person's estate, by virtue of it being registered in a trust. Many people who secure the inheritance for generations and generations to come manage to do so by making use of what is called a trust deed. Let me give you a real-life situation which happened. For the purposes of this discussion, I'll say Mr. Chikeya was married to me, Mrs. Chikeya, and then he dies. After dying, I get married to someone else. And after getting married to someone else, my matrimonial property, the matrimonial property, is given to me. And it so happens that I die before my new husband dies. My new husband now takes the house which myself and Mr. Chikeya would have worked for and uses it as his matrimonial home, which means that our children, Mr. and Mrs. Chikeya's children, are disinherited from what is properly their inheritance by virtue of the operating laws, because the laws say that if a person dies without a will, or if a person dies with a will and purpose to disinherit a spouse of what he or she is illegally entitled to, that will be deemed to be invalid. So which means that the matrimonial home is the right of each and every spouse. So which means that when Mr. Chikeya dies, I'm given that house as my matrimonial home. And if I go on to stay in that house with my new husband, and I die first before that husband dies, that husband has got the legal right to claim that house as his matrimonial home. So which means essentially children are disinherited from the property of their parents. But we can avoid this by registering what is called a trust. Maybe another question which might come is, what are the different types of trusts that are there? The most common types of the trust are, number one, trusts which are made inter vivos. A trust inter vivos is a trust which is made during the lifetime of the person. So which means that I can go when I'm still alive and say that I want to donate my property into the trust, and the property is donated into the trust. And then there are also what are called trusts, which come into existence by virtue of a will, which means that a will can stipulate that once I die, I want my property to be registered in a trust. So which means the trust comes into effect upon the death of the founder or the settler of the trust. And from these broad categories of the trust, we also go down a bit further and have what we call the family trust. The family trust, by virtue of its name, is a trust in which the properties are donated into the trust for the benefit of the settler's family. So which means I can have what I call the Chikeya family trust. There are also what we call business trusts. A business trust, by virtue of its name, is a trust which can be used as a business vehicle, which means that it can own companies, which means that it can trade, but in trading it is exempt from certain taxes since it is a non-profit making vehicle. By non-profit making vehicle, I meant to say that it is for the benefit of the beneficiaries which would have been stated in the trust deed. So loosely, it does not make profit, although it can make profits, but the profits are solely for the benefit of the beneficiaries. So for the purposes of tax returns and what have you, it is exempt from some taxes. In the episodes to come, I'm going to be defining the taxes which we have and how exempt a trust is from certain taxes, the difference between a trust and a company. We're going to be talking about that in the episodes to come. But for the purposes of this discussion, the trust is the most secure way to protect your investments. And even when you get married, it means that maybe you acquired properties before you get married and you want to protect those assets, maybe in the event of a divorce or maybe in the event of death or other eventualities. You can have the trust deed as the vehicle to protect your investments. So my advice to you is that register trusts, protect your investments, protect your properties. So the next question is, how is a trust deed registered? It is very simple. You got your notary public. The notary public drafts what is called a trust deed. You sign to the trust deed. You must have your objects. You must have the property which you're donating to the trust. And you must also have the purpose of the trust. You must have your trustees. And you must have the settler being yourself as well. And you must have the beneficiaries being clearly stated in the trust deed whom the beneficiaries are. And after doing that, the trust deed is then notarized. After being notarized, it is then sent to the registrar of deeds, who then says, well, this is in order, let's register this trust. And voila, you have your trust deed. Your properties are protected for generations and generations to come. I hope I've managed to shed light on how we can invest our properties, protect our investments, and protect our children, protect our parents, protect our spouses from possible disinheritance, which can come about from inheritance with a will or inheritance without a will.